Good morning and afternoon, everyone. I'd like to welcome everybody to day one of our Nonprofit Youth Services Talent Management Summit with today's session on employment law and child safety. My name is Max Smith. I am the Communications Director for 501c Services. We're a 100% employee-owned company that provides full-service unemployment outsourcing programs and other services to more than 3,000 nonprofits around the globe. Our programs include the 501c Agencies Trust, which offers a comprehensive suite of risk management services and tax avoidance solutions to our 501c3 nonprofit members. And we also offer 501c HR Services, which is a confidential resource available to help walk nonprofit organizations through difficult personnel issues. Many of you on today's webcast are already working with us, and I thank you very much for doing so. Now, before we get on with our program, I'm going to try to answer a few questions up front with some housekeeping. If you have questions for our speaker, please feel free to go ahead and throw those in the questions portion of your GoToWebinar browser. Rachel will answer them as we go periodically, so don't hold your questions to the end. If you got a question, go ahead and shoot it in there, and we will try to get to all of them as time allows. Some of you are here for HRCI and SHRM credits. You all know how that works. You have to complete a post-event poll. That poll will pop up as soon as we're done with the webinar. It will also be attached in a link via our post-event email, which you will get at about 1 hour at the conclusion of the event. So make sure you fill out that poll so you can get your credit, and you'll probably get those credits within 24 hours. If you're looking for Rachel's slide deck today, it's already in the handouts section of the GoToWebinar browser. You can download it. It will also be included in that post-event email, as will a recorded copy of the program, so you can watch it back or share it with colleagues. So that's all I have. I'm going to go ahead and hand this off to Rachel, hopefully, if I can get the program to work here. So good morning, Rachel. Rachel is with our friends at Littler, and she's going to take control of the program now, introduce herself a bit more, and go ahead and educate everybody today.
Hi, everybody. Good morning and good afternoon. Hopefully, and Mac hopefully will give me the thumbs up or not. Hopefully you can all see the presentation.
Yes, we'll go. We can see it.
Great. Terrific. My name is Rachel Fendell Satinsky. I'm an attorney at a law firm called Littler Mendelson. I'm based out of Littler's Philadelphia office. I live in Philadelphia, and I am presenting live from my 7-year-old's bedroom. So working from home since last March, as probably many of you are too. I'm really thrilled to be here with you today. Littler is the world's largest labor and employment law firm. We only represent employers. We don't represent individual employees. So in the legal world, we say we are all management side lawyers. And I work with clients on an array of different issues in terms of helping with counseling, day-to-day employment law questions. You know, what do we do with an employee who is taking a leave or who needs a medical accommodation, and helping with policies and processes. And actually a good chunk of my work involves working with camps, so residential and day camps all over the country. Again, I'm really glad to be here with you today. Please do ask questions as we go through this. It will make things more fun for everybody, and keep me on my toes too. So we're going to start by talking a little bit about what does the current environment look like in terms of employment law, and how has that changed over the past few months given our new president? So as many of you are aware, we have a relatively new president, President Biden, and he, from an issue standpoint, is very focused on the pandemic, which you all have certainly heard much about from him and his administration, workers' rights, social justice, and equity. He is very much pro-employee as compared to pro-employer. And so what does that mean for employers? And all of you as employers, what does that really mean for you? It means that we should expect that over the coming months and years that we will see many policies kind of shift in the direction towards being more employee friendly and less employer friendly. So one of the notes on this particular slide indicates that President Biden supports, among other things, the ABC test. And we won't talk too much about independent contractors today, but for any of you who have independent contractors work with your organization, the ABC test is the most employee friendly of the independent contractor tests. So there are lots of different tests that lots of different states and different state agencies use and different federal tests, but the ABC test is the hardest test to meet the requirements of that test. The ABC test is what's used in California, it's used in Massachusetts, it's used in New Jersey, 3 states that are typically very employee friendly. So it will be interesting to see whether there's any kind of federal guidance that comes out regarding use of the ABC test with respect to contractors on a federal level. There's a saying that elections have consequences, and they certainly do. And this is sort of the state of our legislature at this time from a federal perspective. So we have in the Senate an even split 50-50 between Democrats and Republicans. In the House, we have slightly more Democrats than Republicans, not by too much, but slightly more right now. And so this is really the environment that we're working in and that the president will be working in order to kind of look at where things can go and how they're going to go. And this is Joe Manchin, who many of you might say that the most powerful Joe in America is our President Joe Biden. And I would beg to disagree and say that I think the most powerful man in America right now is Joe Manchin. Joe Manchin is a Democrat from West Virginia and really is that kind of 50th Democratic vote. As you can see here, he is the Democrat who voted most with Trump's policy positions as compared to any other Democrat. He votes with Republicans on an array of different issues. He voted in favor of 2 what were known as conservative nominees in Supreme Court Justice Gorsuch and Kavanaugh. And in order to get to that 50-50 split that President Biden will need to pass legislative policies, Joe Manchin has to vote with the Democrats. And so President Biden has to get Joe Manchin on board with whatever he's going to want to do in order to get things across the legislature. Once we have a 50-50 split on a vote between Democrats and Republicans, Vice President Harris comes in and she will break the tie, presumably in every instance, not one that I can think of, she would break the tie in favor of the Democrats. So from an employment perspective, let's take a look at what the new administration looks like in terms of how things are going to affect you as an employer. So Marty Walsh is the current Secretary of Labor. Previously, he was the mayor of Boston, and he has a history working in laborers' unions and being very employee friendly and union friendly, but he also has a good amount of business support behind him. And that's really important because he's not so progressive that we would expect things to go off the rails for employers. He's much more sort of a middle of the road. As you can see, he had the endorsement of the Boston Chamber of Commerce. So he's very well regarded by employers and employees. And Marty Walsh, Secretary Walsh and those agencies under him are going to be those responsible for really implementing and developing President Biden's labor policies that will affect employers all over the country. And here we have some other key Department of Labor appointees who are under Secretary Walsh. Patricia Smith is the senior counsel to the secretary. We have Jessica Lumen, James Frederick and Jenny Yang. Jenny Yang is really no stranger to public service and public life. She was involved with the Department of Labor during the Obama administration. James Frederick has a past, again, kind of more employee friendly, we would say, with respect to OSHA, which is the Occupational Safety and Health Administration. So that administration is the administration that we've been waiting for a while to come down and tell us, what does a workplace look like with COVID, with people who are vaccinated and unvaccinated, and what kinds of cleaning protocols are going to be required with a COVID exposure. We've heard some things from them. We have been, as I indicated, we've been waiting for some weeks to kind of get more information from OSHA, and we do think that's going to be forthcoming. Jessica Lumen is responsible for the Wage and Hour Division. The Wage and Hour Division in the Department of Labor is the division that is most focused on legislation and regulation about pay of employees. That's really important because obviously paying employees has a huge impact on your bottom line, your ability to provide the services that you provide, and your ability to pay employees. So we anticipate a lot of action in the Wage and Hour Division. We think we're going to see a lot of policies changing, shifting back more towards what they were in the Obama administration, away from some of the Trump administration policies that certainly were more favorable to employers. And then Patricia Smith, she, I don't know her personally. I don't know her. She's probably a lovely person. But for employers, she's a bit scary because she knows her way around the Department of Labor quite well. That's probably an understatement, actually. She is intimately familiar with the Department of Labor. She is extremely progressive with respect to policies and things of that nature. And because she's very familiar with the Department of Labor, she knows how to get things done. Again, that's a little bit scary to employers because if she's going to be getting things done, that may mean that we're in for some new laws and regulations that we'll have to deal with as employers. So now that we've kind of laid the framework for what does a new administration look like, what kinds of changes are we expecting? So you've probably heard lots of talk about the increase of the federal minimum wage. There has been some changes on the federal minimum wage with respect to federal contractors. So those entities that provide contracts to the government, the federal government. But there has been talk about increasing the minimum wage on a federal level so that every employee in the country who is not exempt from minimum wage requirements would have to be paid $15 per hour. Again, this sort of goes back to what I said before, which is that these policies will have an impact on employers' bottom line. And that's really where a lot of the pushback is. So while many states have minimum wages of $15 an hour, even more in some states. If any of you were listening in from California, you're probably thinking everyone else is lucky because currently their minimum wage is much lower than in California, where many localities have extremely high minimum wages. We're also going to be looking at changes to what is an employee versus what is a contractor. And I spoke about this a little bit before when I was talking about the ABC test. So if you have independent contractors who are working for your organization, among the many benefits an independent contractor offers is that you don't have to pay them minimum wage or overtime. You don't have to pay them unemployment compensation. You don't have to pay their workers' compensation. You don't have to pay their their portion of employee taxes that you would otherwise pay. And independent contractors do great things for our economy and for lots of different businesses, but President Biden, we should expect to see that it will be harder under his administration to classify a worker as an independent contractor as opposed to an employee. And there are many reasons that his administration favors employee status over independent contractor status. Namely, that folks who are employees are covered by wage and hour laws, they're covered by anti-discrimination laws, they're entitled to Social Security tax, for example, so that they can get Social Security down the road. All things that independent contractors are not currently entitled to. We also anticipate that he is going to increase the threshold for the overtime exemption. So currently, to be eligible for overtime, to be eligible for an exemption from overtime under the federal law, an individual has to make a certain amount salaried in a week among qualifying for an exemption with other factors. We are almost certain this number is going to go up. And what that means is that if you have workers who meet the exemption requirements, so their job duties and what they're doing on a day-to-day basis qualifies them for an exemption, we are expecting that you are now going to have to pay them more to even qualify for that exemption. So again, we're anticipating a lot is going to happen here. Want to touch on the FFCRA, the Families First Coronavirus Response Act. So the FFCRA was enacted earlier in the pandemic, really kind of the first federal response for employers and employees in terms of what obligations are there to support your employees during this really unprecedented time. And so throughout 2020, the requirements of the FFCRA, which are listed on the slide, were all mandatory. So any employer who had 500 employees or less had to comply with these obligations. There was a small exemption for organizations with less than 50 employees that you could apply for to see if you qualified for the exemption, but suffice it to say, this law pretty much applied to every employer under 500 employees. And the reason that it was capped at 500 was this idea that companies over 500 employees were more likely on the whole to already be providing paid sick leave to their workers. Employers under 500 weren't. Again, I don't know personally if I necessarily agree with that, but that was the rationale at the time. So under this law last year, folks were entitled to paid sick leave for lots of different reasons related to COVID. And then they were also entitled to emergency paid FMLA leave, Family and Medical Leave Act leave. These requirements under the FFCRA expired December 31st, 2020. And we all sort of, as employment lawyers, waited with bated breath to see what was going to happen, if this was going to be rolled over into 2021. And as it turns out, it was not rolled over into 2021 completely. So the FFCRA, as of January 1st, 2021, is not mandatory. So these obligations up here are not required. However, they are optional. So the federal government is providing a tax credit if an employer chooses voluntarily to comply with the FFCRA. Now, if you choose as an organization to voluntarily comply with the FFCRA, you have to comply with all of the provisions of the law. So you can't say, we're going to voluntarily comply with the FFCRA by providing the emergency paid sick leave, but we're not going to provide the emergency paid FMLA. If you're going in, you've got to go all in on this. So if your organization, this is something you're not currently using, it's worth taking a look at to see, what kind of savings you could get based on these tax credits. Maybe it's not worth it. It maybe it is worth it. You may be looking at this thinking we already provide these various options to our employees, so we might as well get the payroll credit. But just remember that if you're going to follow the FFCRA, you have to follow all of it. Take a quick sip of water. Here are the reasons under the FFCRA, again, that federal law, why employees can take leave. And so some of them are, I think, pretty obvious, things like being subject to a quarantine or being exposed to COVID or actually having COVID. The ones that were a little bit more expansive are down here, number 5, really, which was caring for a child whose school or place of care, like a daycare, childcare, preschool, was closed due to COVID-19. This also includes summer camps, summer programs. So if you're complying with the FFCRA, remember that this obligation is still in there. That's going to continue through this summer. So, you know, as children go off to camp and other summer programs, this still exists. Thus far, we've spent a lot of time talking about what happens, what's going on at the federal level. And so I want to take some time now to talk about what's going on at the state level. Every state in this country has their own laws, and sometimes they differ from federal law, sometimes they don't. When they do differ from federal law, as an employer, your obligation is to provide or to comply with the most restrictive requirements. So presently, the federal minimum wage, I think it's $7.25 an hour. If you're, for example, in Chicago, I believe it's Chicago and Cook County, I think it's $13 an hour. $13 an hour is more restrictive than $7.25 an hour, so you have to pay minimum wage of $13 an hour. And that's just an easy example, but another one is if your state has more protected classes under its anti-discrimination laws. So for example, your state perhaps protects, I'm trying to think of a good one, but here in Pennsylvania, our state law, among other things, protects family status. That's not a protection offered by federal law, so employers in Pennsylvania have to be cognizant of complying with that. So yes, lots of different laws to comply with. We have the federal level, we have the state level, and then there are local laws too. And so here in Philadelphia, we have many local laws. Many large cities around the country have their own local laws. New York City, Los Angeles, Austin, Chicago. I could go on and on naming them. So be cognizant of whatever your local requirements are too. Sometimes people say to us, well, how do I know whether these local ordinances apply to me? And generally the answer is the person is protected by the laws where they're performing their work. And of course, right now, the next question is, well, a lot of our employees are working remotely. So what if our office is based in Philadelphia, but the employees are working from home in New Jersey and Delaware and all around Pennsylvania? Well, then right now, the employees who are working in New Jersey are protected by New Jersey law, and the employees working in Delaware are protected by Delaware law. And when they come back to the office, hopefully sooner rather than later, they'll be protected by Philadelphia law again. So if you have employees who are working remotely for you, make sure on the whole that you are complying with whatever their local and state, if it's a different state, whatever their local and state requirements are, including time of pay, differences in tax deductions that can be taken out, all sorts of different things. So now that I've given you all a little bit of Law 101, let's turn back to the slide that we have up. And so on a statewide basis, we always expect increases in minimum wages. Every year at the end of the year, there's typically between 8 and 12 states or localities that will say we've made a decision to increase our minimum wage. Some states are doing that in tiers. So they're saying things like in 2021, the minimum wage will increase to X. In 2022, it will increase to Y. In 2023, it will increase to Z. Some states or localities are just saying, for right now, we're just going to increase it to X. It's really important to pay attention to that, especially if you have folks who are being paid minimum wage and are required to be paid overtime. In terms of independent contractor tests, again, we're coming back to this ABC test, and we expect more states to adopt this standard. As I said, right now, it's really California, Massachusetts, and New Jersey. But many more states are moving towards more restrictive tests like the ABC test, making it harder to classify a worker as an independent contractor as compared to an employee. There is a federal law called the WARN Act, which is a law that is triggered when there is going to be a mass layoff. So typically, if there is an entire office shutting down, and there are all different triggers for these mass termination events and requirements for different kind of notice you have to provide, a different kind of procedures that have to be followed for your employees. As COVID really readily taught us, unfortunately, when we're dealing with something as extreme as we are right now, and really as we were last year, there is a federal WARN Act and its obligations, but many states and localities don't have their own WARN Act. And the WARN Act threshold is pretty high on a federal level, so many office closings or mass layoffs, what we would consider mass layoffs, don't actually trigger those requirements. In light of the pandemic and what's happened, we are anticipating that more states are going to be adopting these mass termination event laws that will have lower thresholds. So, for example, it may be required if you have 10 employees who are being terminated, or 15 or 20, as opposed to what the numbers are currently. And then lastly, for those of you who are in California, you're probably not ever wanting to hear the words PAGA, which in California is their Private Attorney General Act, which enables citizens to bring a lawsuit on behalf of a class or group of employees in essentially any situation. California right now is the only one that has this very interesting quirk, I would say. But again, this is something we're expecting to see in more states, especially in those states that lean more progressive. Massachusetts, New Jersey, a number of the states in the Northeast. So something to pay attention to. If any of you have colleagues or friends who are in California, ask them about their experiences with PAGA, because they'll probably make a good face if you're on Zoom or video or something like that when you ask them, just because it's really a difficult law for employers to have to comply with and to have to respond to. And I don't see any questions yet, but please ask away. Even if you think it's a little off topic, please feel free to ask away. What else are we seeing in terms of the pandemic and what impact it's had? Many states have expanded their sick leave laws, and many localities have expanded their sick leave laws, not just the number of hours an individual is entitled to, but also the reasons a person can take what's being called sick time. Lots of states with sick time laws having revised their laws to include various reasons like those in the FFCRA for employees needing to take sick time, everything from having to care for a child to require to be in quarantine or isolation, all things of that sort. Various notice requirements about what an employer has to do if there's an exposure in the workplace, and prevention programs as well. One of the other things we're starting to see too are states expanding their sick leave coverage, and then sometimes requiring employers to create new buckets of time off for employees being vaccinated. So in New York, the requirement, New York State, the requirement is currently 4 hours per vaccine. So that means that if an employee is getting a 2-dose vaccine, they're entitled to up to 8 hours of paid time off, separate and apart from their sick time bank and their PTO bank, to be vaccinated. It's different in every state, every locality. Some states don't have, some localities don't have paid sick time laws. But if you're having employees ask you about, can I get time off to be vaccinated and things like that, take a look at your jurisdiction's sick leave laws and whether there is an entitlement for your employees to be taking that kind of time off to be vaccinated. Just to show you kind of where there are emergency sick leave mandates around the country, you can see from this chart that they're in a lot of the states that I've been talking about, but really every state enacted some kind of emergency paid sick leave measure. So there are many on a local basis, and then there are everywhere on a statewide basis. So these laws are changing quickly. They're going to be constantly changing. The newest kind of statewide laws that are the rage right now, at least in our area of work, are mandatory vaccination laws, and whether states and different localities are going to be enacting laws prohibiting mandatory vaccinations. Currently, no states have that prohibition, but almost every state has some kind of legislation pending in their own legislature about not requiring or not mandating, I should say, vaccinations. So again, very, very timely things that are happening quickly, changes that you kind of can continue to expect to see over the coming months. Here are some examples of the emergency sick leave laws that have been in effect. I've chosen 3 different states. And you can see it's a considerable amount of time that employees are entitled to time off for. Turning back to New York is an example. The employee is entitled to 14 days of paid leave for up to 3 occurrences. Now, there are some nuances in New York about when people have to be paid and what you need in order to get paid. But these are really substantial obligations on employers, and important to be kind of on top of them and to know what's going on. If you're in these states, something else to be aware of, just another thing to kind of add to your list. So in addition to providing sick leave, these are all states that also are prohibiting and have enacted legislation that prohibits retaliating against anyone who misses work because of COVID. So if you're an employer in Texas, technically right now you can retaliate against those who miss work because of COVID. Not that I necessarily recommend that for a whole host of reasons. But if you're in New Jersey, you've got to be very careful in terms of terminating employees who have COVID. Basically, in the states that are listed here, for the time being, you as an employer should consider COVID-19 to be a protected trait. So the kind of care that you take when you're determining an employment action for someone who has a protected trait, or the analysis you're undertaking to look at what risk you may have, same kind of analysis you should go through for anyone who has COVID-19. The next topic I thought I would touch on, and I believe this is actually our last topic, so please do ask away on questions. Otherwise, I'll just keep filling time, but always more fun for me to answer your questions and to address timely things.
Rachel, I hate to interrupt, but there are a couple of questions in the queue about mandating vaccines in the workplace.
Oh, great. Do you want to read some of them out?
Sure.
Or their particular themes?
Let me see. We've got a couple that are similar, so I'll start with this one first. Have you heard anything about people using leave to have children vaccinated, maybe through the EPSL?
I haven't heard anything about taking leave to have children vaccinated. I know the New York law is specific to the individual. I would think probably under most state sick leave laws, taking a child to be vaccinated probably would fall under their general sick leave law. But I believe that the states that have required separate, or the states that are requiring separate banks for paid time off for vaccinations are, I don't think that taking a child to be vaccinated would fall under that. You know, the tough part about employment law is, you know, we have our laws that we follow, and sometimes things are black and white and sometimes they're really gray. But a lot of the time, you know, there is no yes or no or right or wrong answer. And so in that kind of situation, you may say, you know, we don't know of any law that requires us to give time off, paid time off to an employee to take their child being vaccinated. But as an organization, you know, we support public health and we think that's really important. And so we're going to give you that paid time off. You know, and you're doing it out of kind of the goodness of your own heart and employee morale and things like that. And those considerations sometimes weigh much more heavily into decision making than what the legal requirements are.
Okay. And then the next question, we get this question a lot at 501c services too. People are wondering what your experience is with employers requiring people to be vaccinated for employment or for returning to the office, items such as that. What have you seen so far from your desk?
Great question. This is the $1 million question right now. So we are hearing this question every day, all day, multiple times a day. And I will tell you that, you know, our firm in the United States has about 1,000 lawyers. And so we have a pretty good sense and pulse of what's going on with employers. And on the whole, very few employers are mandating vaccines. Most employers are encouraging vaccines. Some are incentivizing vaccines, which is permissible, but really a small handful are mandating vaccines. And I would say of the group that's mandating vaccines, most of that group is healthcare. So, you know, hospitals, other healthcare institutions, other organizations that provide healthcare services really are where we're seeing it. So that's kind of the trend and what we're seeing in the trends. Part of the reason I think for that is that for so long, access to the vaccines has been rather limited. And because it's been rather limited, it's hard to mandate something when people can't access it. And obviously, over the past few weeks, that's changed, and I think will continue to change as vaccines become more and more accessible and easily accessible. So again, that's the trend. From a legal standpoint, you know, today at whatever time it is, I don't know, 2 something East Coast time on May 4th, right now we would say generally an employer can mandate vaccines as long as the employer provides exemptions to that policy for anyone who has a disability or a medical condition that would preclude them from being vaccinated, or for an employee who has a sincerely held religious belief that prevents them from being vaccinated. With respect to the sincerely held religious beliefs, we really haven't heard anything in terms of mainstream religions opposing the vaccine. On the whole, there's some opposition to particular vaccines, but not on the whole. And for a religious exemption, it has to be a sincerely held religious belief. So being an anti-vaxxer doesn't count as a sincerely held religious belief. There are some other nuances that are really important to consider if you mandate vaccines. So, you know, I wish it was an easy yes, no answer, kind of giving you a high level general answer. If you were thinking about mandating vaccines, talk to a lawyer or talk to Mac and his team before you do that. There's just a host of considerations that you need to kind of play through to make sure you're comfortable with that decision and to make sure you have everything in place you need to have. As I indicated, there are some states that have pending legislation regarding mandating vaccines being impermissible. I think the one that is the closest to passing is Montana, but these laws are kind of starting to pop up everywhere. And so I wouldn't be surprised if we see statewide restrictions, kind of in the coming months. But excellent question. We're thinking about it and talking about it every day.
Perfect. I think you've extinguished that question for the time being.
Any others? Any other questions?
No, not right now.
Okay, great. So turning to our last topic, COVID in the workplace, and what does COVID mean for us as we hopefully get back to the new normal? I won't call it normal, but the new normal, and to being in the office again with our colleagues. Going back to our earlier lesson on, federal, state, local laws, and what does that look like? We have, on a federal level, we have the Americans with Disabilities Act of 1990, which requires employers to provide, among other things, reasonable accommodations to employees with specific disabilities or medical conditions. And in 2008, that law was updated with the ADAAA, that essentially expanded very vastly the definition of what a disability is. And we sort of kid that any medical condition qualifies as a disability now, which is maybe a little bit extreme, but almost all medical conditions or disabilities qualify as a disability under the law, except for those that are temporary in nature. So like somebody broke a leg, or something that doesn't affect an employee's daily life activities. Almost every state has a similar law, similar protection afforded to employees who have medical needs. Most of our employment laws on a federal level and on a state level are really focused on what you can't do for somebody because they have a protected trait. So you can't treat people differently because of their sex, or you can't treat people differently because of their national origin. And that's true for disabilities. You can't treat people differently and terminate them because they have a disability. But the ADA and state laws actually provide an affirmative obligation on employers to provide anyone who works for them with an accommodation that helps them perform the essential functions of their job. And the essential functions of their job is a fancy legal phrase basically for the core aspects of their job. Before COVID, frequently an accommodation that employees would request was working from home. And pre-COVID, many employers, rightly so, said attendance at work is a mandatory function, an essential function of the job, and the employee has to be here. Now that we've all been working remotely for the past year, we know that's going to change. It's going to be much harder for employers to say working from home, working in person, and as an essential function of their job, after we've spent the past year and a half proving that many of us can work from home and can do so very effectively. Up to this point in time, most employers nationwide are not back, and certainly are not back at full capacity for those who are back at work in person. And so there are going to be changes to the kinds of accommodations that you're going to be asked about, that are going to be asked for. Everything from needing time off, and how are you going to deal with employees who perhaps there's an outbreak of COVID in your office or in a community and multiple employees need to be off at the same time. What are you going to do if your employees are all in the same community and a school closes because of an exposure or because of a need to quarantine or something like that? And I think that the best thing that you can do is prepare. So, think through what are some of the situations that you could see and how you're going to address those situations if they happen. Best case scenario, you never have to use those preparation plans. You never have to think about them, but you have them if you need them. And I think that's the most important thing. Again, COVID was so unprecedented that we really don't know. We're all learning this together. What is going to be permissible and what isn't going to be permissible. So we're all going to have to go with the flow a little bit, especially as folks go back to work, to see how this is all going to play out. We frequently have gotten the question of, is COVID a disability? And is it? It's going to be very employee specific. I'm certainly not a medical doctor, and I was not a science person in school, hence why I became a lawyer. But just from the general news, we know that COVID affects people differently. Some people don't have any symptoms. Some people have mild symptoms. Some people have very severe symptoms. And so we don't know how this is going to play out, and we don't know how herd immunity is or isn't going to play out. So, sort of keep yourself on your toes with all of this, and just, recognize that you're going to have to be flexible and refigure things as they come. We've talked about, what is a disability and what's that going to look like. And also I've talked about the requirement to provide employees with reasonable accommodations to perform the essential functions of their job. You may have heard the phrase interactive process before. And really, again, fancy legal term for having a conversation with an employee about what their needs are. That's all the interactive process is. An employee comes to you and says, I need an accommodation for a medical condition. You say, thanks for letting me know. Let's have a conversation about what your needs are and what we can do to help you. That's the interactive process. Anything related to employees' medical conditions or requests for accommodations should all be maintained confidentially. Anything that you have in terms of employee medical records or medical files or any medical information should be stored in a separate file, not in their personnel file, but a separate medical file that is in a locked cabinet or if electronic in some kind of password protected system that can only be accessed on a real need to know basis. These are different accommodations that you may run into, you may have already run into, and you may run into in the future in terms of what you're going to have to do for employees who have medical conditions and different needs as they arise. Following that interactive process discussion, the employee's needs may be very basic. The employee may say, I need the flexibility to go to doctor's appointments and leave work every Wednesday an hour early. And you may say as an employer, absolutely, that's no problem. That's definitely something that we can do for you right away. You don't require any further discussion or documentation or anything like that. You may, and I'll give a camp scenario, you may have a overnight camp counselor who says, I have an accommodation, I have asthma, I'm at high risk for COVID, and therefore I can't sleep in a bunk with campers. Well, most overnight camp counselors have to sleep in a bunk with campers, and you're probably not going to create a separate bunk for that person to deal with, and you certainly don't have to reconfigure that person's job. So, where you have a sense that you may not be able to provide the accommodation or the requested accommodation is so significant of a burden on you as an employer, this is the one time where you're actually entitled to get more medical information from the employee, and you can ask them to provide information on what kind of medical condition do they have, what their needs are as completed by their doctor, so that you can really understand, is there some other accommodation we can provide them with? Because employees are only entitled to a reasonable accommodation, not their choice of accommodations. And so that will help lead you down that path. So glad to finish up with other questions that you have on any of these topics or any other employment law type topics. You've got me for a little bit more time, so you should all take advantage of having a free lawyer on for a bit. And Mac, I guess I'll turn it to you to see if there are questions that we can address.
Okay, we'll wait and see if any, get the keyboard warriors going. See if anybody has any questions here at the end.
I see for some reason I can see one where somebody said, have I been hearing of service organizations mandating that staff be vaccinated? And I talked a little bit about that in terms of what we're seeing trend-wise with requiring vaccinations. I would say, service organizations probably are more on the end of those we are seeing mandating. But again, in terms of vaccines, we're really not seeing a lot of employers mandating, mostly encouraging strongly and providing different kinds of incentives to their employees to be vaccinated. Sometimes we're asked, what kind of incentives are employers giving? We've seen everything from raffles and pay time off in states that don't have that requirement to things like extra PTO, an extra day off, an extra night off, all different sorts of things we have seen in terms of encouraging and incentivizing. I actually was looking at an email before this presentation that was asking about, have we seen certain incentives be more convincing than others? And I don't think we have. I think on the whole, what we're seeing are extra paid time off is a very common incentive that we're seeing. It's something that's helpful for employees. They like it. Things of that nature. If there's no questions on this, I can kind of talk a little bit about vaccines too. We have frequently gotten the question of, can we ask our employees if they're vaccinated or they're planning to be vaccinated? And the answer to that question is yes, you can ask that question. So you can ask the question of, are you vaccinated or are you planning to be vaccinated? Yes, no. Or have you been vaccinated? Are you fully vaccinated? Yes, no. We all want to ask that next question of why. So why, if you're not vaccinated, have you chosen that? And I caution you against asking the question why, because you may unwantedly, I don't even know if that's a word, but you may be getting feedback from employees that they're not being vaccinated because of medical conditions or religious beliefs or other information about them that you don't want to know. So, if you're going to ask that question, definitely just ask the yes, no. If you're going to compile information on an organization-wide basis, so you're going to say, okay, we know that 50% of our organization is vaccinated, I would suggest that you keep all of that information confidential that you get back. If you're getting individual information, so if you're sending out an email and saying, please respond to me if you've been vaccinated, yes or no, so that you can identify that Rachel, for example, has been vaccinated, then again, you want to store that confidentially in an employee medical file. For those of you in California, California does have some different data requirements in terms of storage of data, and so just be very careful if you're storing things electronically in California with respect to that kind of information. Also, obviously careful everywhere with revealing that information. So if there's a question of, who of your employees are vaccinated, be very careful providing that information. Certain disclosures are needed in California and in other states before you can provide that information. Another thing to kind of be careful of is, in your world, you may have people who participate in your programs or your organizations as children, and you may know their families, and out of the goodness of your heart and the goodness of your spirit, you may want to call Rachel's mom and dad to say, hey, Rachel hasn't been vaccinated yet. I think this is a really good idea for her. Remember that if Rachel's over 18, it's her medical information. And although you may think you're acting in her best interests, you really need to take a step back because once somebody is 18, they make their own medical decisions, and releasing their health information can be a violation of a lot of different laws.
Rachel, we do have a couple of questions from a lot of the folks on today are with child care organizations. Have you heard anything? Are you aware or experienced run-ins with any mandates that child care organizations might be having issues with? For instance, there could be social distancing rules, and if you're running a daycare, obviously that becomes an issue. You can't keep a mask on a 4-year-old sometimes. So when we're talking specifically about child care organizations and the mandates they might run into, do you have any experience with that over the past year?
So really what we do is advise employers. So I can't speak so much to, requirements for children and the ability to comply with requirements for children, but speaking to your obligations as an employer and your staff and things like that, obviously you want to be sure you're following, local and state requirements on mask rules. There are obviously there is new guidance from the CDC around what folks who are fully vaccinated can do with each other. And certainly in a daycare setting, probably all of the children are not vaccinated, even if all your staff are. And so those masks need to continue to stay on at this point in time. You know, anecdotal experience from my own 3.5-year-old who's in preschool. It's hard. It's very hard to get a child to keep a mask on all the time. And so, I encourage you to think about doing things like mask breaks and saying, okay, we're going to go outside and, you can stand here and you can stand here. My older son's school, they have their mascot's a tiger. And so they have tiger prints printed on the ground 6 feet apart outside so that the kids can take mask breaks outside and sit 6 feet apart to take those breaks. They do the same thing when they eat lunch. So there's a lot of different things you can do. If you have specific questions about specific things, feel free to email me. I can go back. My email is in the beginning of the presentation, and I'll just put it up here. But feel free to email me, and I'm glad to kind of give you whatever other insight I can too.
And there's just to piggyback on what you talked about earlier about being able to ask people if they've been vaccinated or if they plan to be vaccinated. We've got a couple of questions in the queue about kind of more specific details. If can you request evidence of a vaccination, like a copy of the card? Can you request people prove that they have a negative test if they leave the country and stuff like that?
So I'll take those sort of separately. So can you request a copy of an employee's vaccine card, for example? Yes, you can. Again, if you're going to request a copy of it, make sure that's kept confidentially. That's fine to ask for it. We've heard, again, kind of anecdotally that some people lose their cards or that the cards are really just a piece of card stock with some print on it and easy for somebody to forge. I think it's a lot of effort to create your own vaccination card falsely, but apparently that's happening in some places. So we've seen the request for vaccination cards. Again, that's fine. We've also seen a request that employees provide like their own attestation that they have been vaccinated if they're saying they've been vaccinated. You could do that pretty simply by asking employees to send you an email saying that they attest that they've been fully vaccinated, as previously indicated to your organization. So all of that's fine. Again, if you're going to keep information about whether someone's vaccinated, keep it confidentially. I've probably said that 10 times today, but really can't be said enough. The other question, which I believe was in terms of a positive, whether you can do a test.
Requiring proof of negative COVID tests. A couple of the examples were people going on vacation, maybe if they leave the country. Another example was if someone's child gets COVID, can I require the parent to give me a negative test before they come back? So maybe you just need to talk about testing in general.
Yep. So with testing, you're going to want to look at what your state and local requirements are. For a while in Philadelphia, you could test if there was an exposure in the workplace and some different things around that. So take a look at what your local mandates are saying first and your, local permissibilities. For a while here in the Northeast, there were restrictions on going out of state. And if you came back in state from a statewide perspective, you had to quarantine for a certain amount of time or produce a negative test. So some states, at least around here in Pennsylvania, I don't think that that requirement exists anymore, but I do think that requirement does exist for a certain international travel. So, and I'm not off the top of my head familiar with exactly which countries and what, but on international travel, take a look at what the requirements would be for somebody returning to the US. And if they would have to provide a negative test result, you can certainly ask for that. Again, this is one of the areas where there really hasn't been that much guidance because people haven't been back to work. So they're working from home. It's not really an issue. They're around their family who they were traveling with, and something that I suspect we'll see kind of more down the road. If you're going, just kind of a point of caution on tests, if you're going to ask employees to be tested through some kind of third-party provider, make sure that you get an authorization from the employee for the third-party testing provider to provide you with the test results. You may be just asking the employee to provide the test results themselves, which is fine. But if you want the testing company to provide you with the test results, then you have to get the employee's consent in order for the testing company to release those records straight to you.
Okay, great. Well, Rachel, we're out of time, but we didn't leave a lot of questions left unanswered. But like Rachel said, everybody, if you have any further specific questions, please feel free to respectfully bother her. Don't take too much of her time. But thank you, Rachel, again for being with us today. Thank you, everybody else. Remember, we have 2 more sessions this week. You can go to our website, 501c.com, and you can register for Wednesday and Thursday session if you would like. And if you need that HRCI or SHRM credit, as soon as I close the webinar out, that poll will pop up for you. But thank you, everybody. Have a great day, and we'll see some of you again tomorrow. Bye, Rachel.
Thanks, everybody. Bye.